I welcome you all to this second video of the series titled Create Powerful Legal Arguments. I must say I'm very excited to come on YouTube today and share with you what I have learned in this past so many years of doing very intense research into the argumentation process. As I said in the last video, I have given about 100 talks to my friends on Sunday mornings, and they all asked me to put it on YouTube, and so here I am. Now, in the first video, I had told you the outline of the roadmap we are going to go, and if you see the description at the bottom of the video, you will find the roadmap given to you and how I'm going to proceed. I also told you how we're going to use the concepts of processing the material, crystallizing the material, crystallizing the arguments, and later on different concepts of executing the arguments. I have no doubt that if you follow the systems correctly, as they say, if you use even some of the systems correctly, it'll make a big difference to your argumentation. And if you use all the systems, the results will be explosive. Mr. R M Bapat, the Justice R M Bapat, who now retired, of course, was pleased to give me an endorsement here. He said that this system is going to make a very big difference to advocates and going to raise the level of argumentation everywhere. With this in mind, I will start my talk today. The talk today is focused on the purpose of argumentation. What is the purpose of your coming to the court and arguing for the judge? Now, why it is important to understand the purpose? Because most lawyers go through their entire careers without understanding the purpose of their argumentation, and that causes a lot of problems. It causes a lot of problems in direction and the court listening to you, court opening up to you, and all that. So today we are going to examine, in very brief, the purpose of argumentation. Like I said just now, why is it important? It's important because it gives you direction in your arguments. It's also important because then you modulate your argument, you condition your argument so as to make it more acceptable to the judge, because only if he is interested in listening to you, he's going to give you a full audience, otherwise he will not. And thirdly, most important, it is likely that if you are clear and if you are suiting his purpose, he is a little more inclined to give an order in your favor. So all these things matter as to why the purpose of argument is important. Now, if I put it in one single line, I'll put it this way, that the purpose of arguing in the court is to assist the judge to write a judgment. When I say court, I also mean authority, so take it in that way, to assist the court to write a judgment. Now, why does it need your assistance? Because conceptually, he is really speaking involved in the decision-making process, and he needs your help in processing and finding judgments and crystallizing the judgments. And his real job, conceptually, his real job is to appraise what you're saying and formulate his decision and pass an order accordingly. So there is a conceptual aspect of it, but in ordinary terms, it is like that you must assist him to write, right from beginning to the end, to write his judgment. Now, if you analyze the functions of a judge, there are two basic functions. One is the judicial functions and the other administrative. In judicial functions, he is supposed to hear both the sides and appraise what both sides are saying, come to conclusions, find out the issues involved in the matter, and come to a decision and pass a judgment accordingly. Now, he needs your assistance in all these areas, because otherwise, if he has to, technically, if he's asked to do everything himself, it's going to take an age. It's going to be very difficult for him. So he needs the assistance of advocates. And here is where we come in. If you are not able to put forward your argument in a way that assists him to write a judgment, in all probability, he's not going to listen to you. He's not going to give you that intent listening, active listening that is required. Now, what are the different facets of assistance you can give to the judge? One thing is by clarifying the relevant law. I will just enumerate a few of these and develop it as we go along, maybe this video or the next video. because this area is very vitally important. By clarifying the relevant law, by denoting the objective of the act, by clarifying concepts to be attained by the court, by the legal and factual structures that are required, and by explaining the relevant case law to the court and helping to apply the same to the facts of the case. You see, the entire range of activities that the judge needs you. Otherwise, if he's going to do, like I said just now, if he's going to do it himself, it will take him a long time, and besides, he may not be able to give proper attention to the decision-making process. Now, we have to explain sometimes the mechanics of writing the judgment. Sometimes it's difficult. He may not know the mechanics of it. For instance, in matter when he is going to refer the matter to the High Court for contempt, unless you give him the format of the reference, he's not going to pass it. I mean, he's going to just delay it. So sometimes you have to assist him even by giving him the format of the judgment, or the format of the argument, format of the decision or the judgment, to enable him to proceed further. Now, it is a very big advantage in Bombay that the courts expect you to write a synopsis of your case right in the beginning, and without that they don't accept the matters. So in a synopsis, you have to give the outline of your case in short, very short, and what the case is about, and basically the chronological order of the matter, and the points that you're going to raise, and finally the judgment that you're going to use, and the law and the case law that you're going to use. So you see the format is there. So it's very easy for the judge then to look into your matter synopsis and find out exactly where you're going. And thereafter, after you come to the clarification of the various facets involved, then you have to go into what is called decision-making process. If you can, in law, legally and ethically, if you can control his decision-making process, it will be a great advantage to you, because if you do that, then you'll be able to, it's more likely that you'll get an order in your favor. So I'm going to go to each of these areas in some depth, but we'll start by saying that when you go to write assist a judge, what sort of assistance he needs and wants. So if you see any judgment of any court, you will find the first paragraph relates to the outline of the type of case it is. I mean, type of case, the particular type of case that is being looked into. For instance, if it's a specific performance suit, or a writ petition, or a commercial suit, whatever, the first paragraph tells you what exactly the suit is. And therefore, when you argue, first you must pin down exactly what type of case you have got, in short, because then that creates a certain focus in his mind. In his mind, in the judge's mind, he knows what to look for and what not to look for. So it cuts down all the irrelevancies and goes on into the particular type of case, the particular class of cases, a rent case or a writ or a whatever that is. Now, if you do that, therefore, first thing you have to assist him by telling him the type of case there is. After that, in short, very short, you have to explain the direction of the case. That is what you're expecting. I mean, after saying what type of case you're filing, then what are your expectations here? In very short, that for instance, you may say that the petitioner in a writ petition is praying for whatever he's praying for. Can put it that way, so that he gets a focus into what the case is and what your prayers are. So within that, then he can think, and he'll be able to focus his attention on those areas. If you don't do that, if you don't know what he is looking for, then you're not assisting him. And then if he's going to read the file himself, then you lose control on the mind of the judge. That's one thing you cannot lose, or not to lose, because you should not lose control on the mind of the judge. Now, because if he's going haywire, and he may go haywire, and then you have lost control. If you lose control, you will lose the case. So this is how we have to proceed. Now, if you see, the intention of the judge to listen to itself will depend on how much assistance is getting from you. If he's not getting assistance from you, if he's getting confused, you look to the file, and then you have lost your opportunity to influence him. To a great extent, you have lost your opportunity, because if the judge feels that you're not clear enough to assist him, he's not going to listen to you further, even on fine points. He's not going to listen to you. So the first aspect I'm going to tell you today is to pin down exactly what type of cases it is, pin down what exactly prayers you are asking for, and your entitlement and your prayers in very short. So that creates a certain focus. And once you've created this focus, we will tell you now in the next video how to take it further, and what further is required, what is required further to clarify the various facets of the judgment in which you are going to assist him. Now, in the next video, I'm making this video a little short, but so that you get attention. In the next video, I'm going to explain this area a little more, because it's only this area that is going to open up the mind of the judge, so that he listens to you on the finer and the more relevant points. So thank you very much. I will further this talk in the next video, and every week I intend to give you one short video for a start to explain some concepts to you, so that you develop your intellectual skills and argumentation, and hopefully you do better in the court. So next video I'll explain this concept a little further, so that next argument you make, you should be able to handle this area without difficulty, and sooner or later you'll be able to get to argue in a matter that is going to get you results. Thank you very much. We'll wait for next time. Thank you very much.